Okay, let's let's return our task. Example cases. How does your maritime case compare? Despite the thousands of maritime injury cases involving Houston-based maritime firm and their employees, there are always something that new that comes around. The following cases from around the U.S. set precedents for similar cases that may follow. Hoffas versus American Seafoods 2018. American Seafoods, owner of the ship American Dynasty, was found negligent for not providing a safe work environment for a crane operator who fell trying to reach a control that should have been more accessible. The worker was required by his supervisor to operate a midship crane on the trawl deck. Normally, the crane could be operated by a wireless remote control, which allowed workers to use the crane during inclement weather. However, on the day of the accident, the remote control was not available, having been taken out of service by the chief engineer so that the crew wouldn't misplace it. In order to use the crane, the workers had to climb a ladder to reach the control tower. The ladder was substandard, even by written company policy that asserted that the ladder must have evenly spaced rungs. This ladder did not have evenly spaced rungs on a handrail, and the worker fell, suffering a serious knee injury. The case was won on the basis of the ladder that didn't meet even the company written safety policy. The judgment was worth 900,000 US dollar. Michelle v. Trawler Racer Inc. 1960. This case went all the way to the U.S. Supreme Court and established a modern precedent for what constitutes seaworthiness and reasonable care. Francie Mitchell slipped on the stairway aboard a fishing trawler racer when he encountered slime on the handrail. He sued on the basis of negligence and now the ship unseaworthiness. The ship owner said the condition of the handrail was unknown to its crew, was temporary, and that reasonable care had been applied in the maintenance of the vessel. A jury sided with both parties, allowing Michels to collect on standard maintenance and cure for negligence as provided by the Jones Act, but ruling for the defendant on the charge of unseaworthiness. Mitchell appealed the ruling, charging that the presiding judge was in error when he instructed the jury that in order to rule the plaintiff petition for unseaworthiness, the defendant have known about the slime on the handrail and choose not to address it. The appellate court sided with the court based on the presumption that the plaintiff had failed to prove the ship's crew knew about the slime beforehand. But when the case eventually reached the U.S. Supreme Court, the case was overturned. In writing the opinion of the court, Associate Justice Porter Stewart said that the ship owner's responsibility to provide a seaworthy vessel goes beyond simply applying reasonable care, and that a temporary condition that renders a vessel unseaworthy doesn't relieve the owner of the liability. Kiltrix v. Carlock Marine Inc. 1995. Kiltrix, first name of Nat and Philip, was severely injured when a manual crane handle that he had laid on the top of an electric winch flew off of the winch when the winch suddenly activated. He had been using the manual crank to free the winch, which had become stuck. The crane handle struck Coutrex in the eye and face. Coutrex sued the Scarlock Marine for negligence and failure to provide a seaworthy vessel, saying he had not been properly trained in the use of manual crank. Scarlock countered, saying Coutrex had been throughout trained on the Talbot Brooklyn when the accident happened and had been trained specifically on the use of manual winch crank. They said should have exercised better care for his own safety. According to a Jones Act, a seaman needs to exercise only slight care for his own safety, while his employer is held to a much higher standard to assure a safe work environment. Scurlock attorney argued that the court has blindly followed by an incorrect statement of the law. According to the Jones Act, a seaman need exercise only slight care for his own safety, while his employer is held to a much higher standard to assure a safe work environment. Scarlock's attorney argued that the court has blindly followed an incorrect statement of the law. The court said that regardless of the corrections or failures of the slight care provision of the Jones Act, it could not alter it, adding that it would be a humanly higher cost to change the interpretation of the law and lawmakers to change the laws itself. The jury apportioned 95% of the fault to Scotland and 5% to Caltrox and awarded him 854,000 US dollar. That figure was later reduced by an appellate judge for 736,000 and 925 US dollar. If the case example above leave you scratching your head, you're not alone. Maritime law is complicated subjects to various interpretation and subject to revision. You best join for resolving your maritime injury case is Patrick Daniel Law. Patrick Daniel started out working maritime injury cases from the defense side. He cut his teeth, learned the trick of maritime negligence defense, concealing evidence and witnesses, delaying tactics, stalemating, and intimidation. 20 years ago, he switched off the plaintiff side of maritime laws and became a passionate advocate for those suffering from marine injuries. He is not only a master craftsman in the courtroom and the negotiating table as an expert trial attorney, but he also knows the work. He is Louisiana native and grew up around the people of the maritime industry. He's even represented people working from other continental shelf and high seas, including offshore oil rigs, jackup rigs, drilling rigs, and car handling vessels, towboats, screw boats, and more. Okay, thank you for your attention, and see you.